Good day to you all. My name is Kasha and I'm the group leader of the group that is going to present on the Contractual Penalties Act. My assistants or my fellow colleagues are Tafadzwa Marwanyika, Adeline Bimbai Simbo and Pride Chinembiri. And together we're going to be dealing with selected parts of the Contractual Penalties Act. I am going to look at the purpose of the Contractual Penalties Act, whilst my colleagues are going to divide themselves amongst the application of the Contractual Penalties Act and the effects of that particular act within the contractual law domain and the basis of the Zimbabwean contractual law and commercial law application. The Contractual Penalties Act is an act to provide for the regulation of the rights and obligations that arise from parties contracting for the sale of land by installments and to regulate contractual penalty clauses within certain contracts in the commercial law domain. It can be said that the purpose of the Contractual Penalties Act is to ensure that there is equality and fairness in the domain of contract law, and to ensure that penalties are not unfair or unequal or upset to such an extent that they prejudice one of the contracting parties. The Contractual Penalties Act, just like any other act in commercial law and in contract law, is set to make sure that there is consistency and there is certainty within the domain of contract law, but that is not, however, so certain because there are issues in their provisions within the act which allow for courts to apply their discretion in matters whereby they can rule out or choose not to enforce a penalty clause in an instance where it prejudices an individual party. And this paragraph or section in a contract which stipulates what penalty a party may be liable to if they breach a contract. There are various types of penalties, and the most common type of penalty is forfeiture of amount of money that would have been paid by a contracting party to a contract, right? But however, the enforcement of the penalty or forfeiture is subject to the court's discretion, as stated in the case of Scotfin Limited versus Ngomauru Limited. The Contractual Penalties Act renders the enforceability of a penalty clause enforceable to the discretion of the courts. That is to say, the court has the ability to choose to enforce a penalty clause or not to enforce a penalty clause to an extent where it is going to prejudice the contracting parties or it is unfair, or may seek to enforce another relief that it may see so fit for that particular contractual breach. Sure that contracts are just and fair and there is no unequal treatment, and the purpose of the Contractual Penalties Act in relation to this particular provision is to achieve a balance of fairness and justice and equality in terms of situations whereby there is an equal bargaining power between contracting parties. It is always the situation that there can never be equal bargaining power in a contract, or it is very difficult to establish equal bargaining power. That is to say, there's going to be one party that might be disadvantaged by a contract, and in such instances the court has the duty to ensure that there is fairness and there is justice in relation to the Contractual Penalties Act, and that can be attributed to the purpose of the Act, since such provisions are provided for by the Act. Also has a purpose to regulate the rights and obligations that arise to parties that contract in the sale of land by installments. Basically, this can be applied to the sale of other immovable properties, but the Contractual Penalties Act specifically deals with the sale of land by installments because it is a prevalent issue within the context of Zimbabwe, and the situations are arisen whereby people buy land and then they fail to pay through installments, and then they fail to pay the full amount that is amounting to breach, and in such instances whereby a party fails to pay a certain amount of a deposit or a certain amount of that particular installment, you find that other parties might want to cancel the contract, and then keep the money. But the Contractual Penalties Act actually provides for when such particular provisions of forfeiture exist and when such provisions of forfeiture cannot exist. That is to say, the Act in its essence is there to make sure that there is no unequal bargaining of power. This is done to ensure that there is no unfairness in an instance where certain parties want to take advantage of a party's failure to pay a certain part of installment and cancel the contract and claim money that has been already paid, right, and have that breaching party forfeit his or her money as a penalty for breaching the contract. And henceforth, the penalty clause seeks to regulate those rights and regulate those obligations by giving contracting parties an allowance for when they breach a contract of sale by installment to be given a notice of 30 days or more to notify them of that breach and to take action. And cancellation cannot take place before the annulment of those 30 days. And that is how the Act regulates the sale of land by installments, where there is a breach and a penalty seeks to be imposed. Other penalties that may be imposed might be the payment of money or the payment through other property or whatsoever rights. But the main common one is the forfeiture of money in the sale of land by installments. So I'm going to leave the rest for my colleagues who come and finish the application of the Contractual Penalties Act and the effects of the Contractual Penalties Act.
And I'll be carrying on from Herbert Chitepo to discuss the application of the Contractual Penalties Act. So contractual penalties are stipulations or clauses that are found within specific contracts between people which attempt to regulate how they are going to be conducting their business. They can be expressions of what consequences will fall upon someone who breaches their end in an agreement when it comes to a land lease or when it comes to any other stipulations that they may have. Contractual penalties originate from 13th century England, where they were discovered, where the King's Court discovered the need to have a specified procedure and regulations that could be used in order to deal with matters that pertain to contracts and relations between parties and people. So the penalty stipulations simply mean that what are the contracts or provisions within the contract that are made specifically for dealing with a party which is liable for this. And this may include the obligation to pay, to perform a duty, and they may include the need to forfeit money when such happens. It can also be an act or omission that can be found that is in conflict with the contractual obligations. The most common type is found under breach, where parties agree to pay a specified set amount of money at failure to perform the task that they were supposed to perform. These can be common between buyers and sellers, where a party may have entered into a contract to attain certain goods or products from another producer, but having decided to breach that agreement, leading to harm or loss on the part of the producer. This may have to lead to the contractual penalty clause within the contract being activated. The Act provides that such clauses are enforceable by law, and the courts are given jurisdiction to attend to sorting out matters when there is a mix-up that happens between two parties that entered into a contract to provide each other with material. In the Scotland Limited versus Goma case, it was discovered and ruled that the court is given jurisdiction to actually take care of these clauses that are given in contracts, to enforce them or even to refuse to enforce them as per the jurisdiction that the court has and by the authority that they use to try and determine whether or not the enforcement would be just and valid or would be illegal. So where the agreement for these contractual penalties has been made in the terms of installments or in terms of lands or whatever parties may have agreed to, the court is actually able to determine whether the contract, the term itself is just and appropriate for application. In the Gurure versus Usike case, the court emphasized that, especially under Section 8, no seller was allowed to terminate a contract without having given prior warning with the effect of at least 30 days. And it was determined that such provisions as were in the clause were liable for enforcement, just that in this particular instance the breach had occurred before the Contractual Penalties Act had come into being. There are many types of contractual penalties that vary in how they are applied. A common type that is used is the car lease. The car lease is when a vehicle is rented by specific parties, and this party may want to use the car for a specific set time, and they are provided with the person who is renting that there is a specific mileage you must not cross, and there's a certain wear and tear that the car must not pass. And the car will be used if the person was allocated 10,000 to 12,000 mileage. If they cross that, they may have to pay for each mile that they exceed the mileage. And in the terms of wear and tear, which is excessive, if the car displays more harm or excessive damage to it, more than is expected for the functioning of a normal car, it may be determined that the person may have to compensate for the damage that has been done to the car. Contractual penalties may also apply particularly to rentals, where it can be determined that if the tenant exceeds the date of paying rent, they may have to pay an increment of 5%, or they may have to pay in interest per each delay every week or maybe every month until the date that they settle their rental payments. And it is also certain that the same can also apply under several types of provisions like land lease, or under other methods that can be utilized to pay for this. The application of Contractual Penalties Act also falls in line with the constitutional provisions. It applies under the horizontal application, where certain contractual penalties may not be viable for application due to their failing to conform with the constitutional provisions that have been set. And this may mean that just as the courts have their own jurisdiction, and just as the courts can determine how they wish to apply these contractual penalties, the constitutional rights that are afforded people may also be considered in determining whether a specific penalty is viable, and in determining whether the damage that a claimant here is claiming is not excessive or misproportionate to how much they should actually be afforded. Thank you.
And I'm going to be continuing from where Maralanika left. Based on the Contractual Penalties Act, it also focuses on issues to do with sales, especially the sale of land under installments. According to Section 7 of the Contractual Penalties Act, land sales are actually supposed to be in written form. This is because when there is a breach, there is at least a written form to prove that there was the existence of the contract. In case there is no written form, the person who alleges that there is the existence of the contract is supposed to be the one who actually proves that there was the existence of the contract. He who alleges is to prove. When we are talking about land sale paid in installment, is whereby the purchaser is supposed to deposit a particular amount of money and finish off with other installments, or they can start with an installment and then finish off with other installments. The issue pertaining to land purchased on installments is whereby the owner, who is the seller, actually retains the ownership of the land until the purchaser is successfully and fully paid the installments in time. This can be done over years or even less, that is weeks. However, when the purchaser actually fails to fulfill the obligations of the contract, that is to pay the installments in time, there exists a breach. And a breach does not necessarily give the seller the right to claim for the remaining amount of money, that is the installment that is not being paid, or demand for damages in that exact position, but rather Section 8 of the Contractual Penalties Act actually limits the seller's right to. Section 8 of the Contractual Penalties Act is there to regulate the issue pertaining to where there have been matters of breach. The purchaser is not supposed to jump quickly to claim for damages or to force the purchaser to actually pay for the damages for not having paid the installments on time, but rather there's a procedure to follow which involves the purchaser actually notifying the seller actually notifying the purchaser that there is the issue of breach and what type of breach. The notice pertaining to the solution should be at least taken into consideration for a period of 30 days so that the purchaser can actually have the opportunity to remedy the breach, and thus this cause. Illustrated in the case of Kakomo, it is evident that the courts can actually use their own discretion when it comes to penalty stipulations. Whenever a penalty is actually high enough, the court can actually reduce the particular penalty to a price that is fair and just. But however, where also the penalty is too low, the court has the discretion to actually raise that penalty provided there has been a breach. The case also illustrates the issue pertaining to installments that land sales can actually be where a purchaser has actually breached the contract. He is actually supposed to forfeit his right to expenditure and the installments that he has already paid. Another specific type of contract that is regulated by the Contractual Penalties Act is the Construction Act. The Construction Act is another type of contract that is regulated by the Contractual Penalties Act is the construction contract, which is a written document that lays out the obligations and terms that the contract and contracted are actually supposed to fulfill in a particular period of time. This is when the issue pertaining to liquidative damages come in when the contractant fails to actually finish the contractual obligations on time. Liquidative damages ensure certainty because the contractants are actually obliged to finish the contract on time, and they do so knowing that if they fail to do so, it's a breach of contract, and therefore they're entitled to pay a particular amount of money. Therefore, in contract, we see that certainty is promoted through these liquidated damages, and also the payment of money if rent installments are not made in time. I will leave the rest to my other co-counsels who will finish on the effects pertaining to the Contractual Penalties Act.
Guys, I'm Pride Chinembiri, and me and my colleague Adeline, we are going to be doing the effects of the Contractual Penalties Act of Zimbabwe. So basically, there is the deterring effect. What does it say? To deter is to stipulate a certain action that a certain person will undertake if he commits a certain offense or an action. So basically, in contracts, by deterring a certain penalty, we are setting a penalty that says if you breach a certain obligation of a contract, you will be bound to that penalty. Hence, this deterring effect has actually increased the number of contracts being undertaken in our Zimbabwean context because people, whether juristic or natural persons, have the fear of undertaking certain penalties whereby you might be forced to pay compensation in the form of damages such as money. So this Contractual Penalties Act has set certain penalties to say if you breach this contract, you are bound to pay this. Hence, people being afraid to pay those penalties, they actually end up undertaking those contractual obligations. For example, in our Zimbabwean context would be a contract between two people. For example, let's say Chinembiri Bakeries and Maravanyika Deliveries. So I enter into a contract with Maravanyika Deliveries for him to be able to deliver my bread across Zimbabwe. And the Contractual Penalties Act might stipulate that failure to honor a delivery contract, a certain party will pay damages, let's say $200,000. So with fear of failing to pay such huge amounts of money, this will actually lead to Maravanyika Deliveries to actually undertake his obligation, because guys, $200,000 in Zimbabwe, that's a lot of amount of money. So basically this has increased contracts being undertaken due to fear of paying certain compensation. However, the deterring effect has a drawback, whereby some penalties set by the Contractual Penalties Act might be too low for certain companies. For example, we have Delta in Zimbabwe. If you set a penalty of about 5,000 for failing to undertake a certain contractual obligation, that figure might be too low for a company like Delta. Hence, they will not honor their contractual obligation in the sense that they will be willing to pay that 5,000. Hence, there's a gray area there that needs to be further developed by our courts. Thank you, guys. That was the deterring effect. So my colleague Adeline will be following up with remedy and certainty. Thank you.
Contractual Penalties Act bring in certainty in the sense that it denotes clarity in the parties' contractual obligation. This is called the certainty effect, where parties agree that in the case of breach, there is a certain written down method on how to either dissolve or remedy the breach contract. Section 8 of the Act, to be particular, brings this certainty where it is stated, where it states reasonable period of 30, not less than 30 days to remedy breach. As it is in the case stated earlier by my colleague of Gurure versus Rusike. Moving on to the remedy effect. Section 4 covers most of the remedying effect. That's where the court might or may order the creditor to refund to the debtor the other part of the installment or all the part of the installment, or where the creditor reimburse the debtor the whole part of the expenditure that occurred. However, the court also uses the judicial discretion that was mentioned in the case of Coffin versus Ngomahuru. However, whatever the court's discretion prescribed, it must grant a relief that is just and fair to both parties.
So once again, ladies and gentlemen, it is I, Fianchi Kasha, here to round up in a nutshell what we've presented on the Contractual Penalties Act. So what we've just generally presented on the Contractual Penalties Act are the purpose, the application, and the effects of the Contractual Penalties Act, of which under the purpose we've spoken about what exactly the Contractual Penalties Act seeks to achieve. Under application, we've dealt with how exactly it has been put in place. We've dealt with how it has been put into practice with regards to certain cases, as the ones that have been said, such as the Gurule case and that of Ngomahuru and Scotland Limited. Led by Adeline and Pride Chinembiri, we spoke about the effects of deterrence, bring about certainty within the contract law domain, and the effect of remedying, the issue of remedying breaches that exist within contracts where penalty clauses are existent, and in certain contracts such as that of the sale of land. And with this, ladies and gentlemen, we say thank you for giving us your ears, and this is us coming live from Great Zimbabwe University.
It's the seller's right to Section 8 of the Contractual Penalties Act is there to regulate